participate.
Okay, no, that's correspondence yesterday from from Mr. Dupree. He is not yet ready to brief us. He will be ready to brief us on Tuesday on the A list for the land court bill. Hopefully, we will be able to finalize the bill next week and move to the next bill, which will be hate crime, hate speech bill. Members, are there any apologies?
No, Chair. Except that, can you wipe your gadget camera? You look blurry there. It looks like you are in the middle of a mist.
Oh, thank you very much, Honorable Ngola. Let me try and tell you that. 1 minute.
When one ANC member is out from under the trees, the other one goes into the mist.
Honorable Horn, come on.
Recording in progress.
Proper, Chair.
Thank you very much. Thank you very much, Honorable Ngola. Honorable Horn, I'm watching you. I'm watching you.
Chair, can I just come in quickly? Honorable Ngola doesn't even have his camera on. How come he can criticize you when he doesn't even have his camera on?
Oh, it was a progressive criticism. Honorable Horn, I'm watching you. I've got Honorable Jancho online. Honorable Masako Chele.
Good morning, Chair. I think you have to move to the middle of the picture, because the thing that makes you to have that blurry gray thing, it's this light. It's like it's the window. I'm not sure what is it.
The window, okay.
You always sit towards the middle of the picture.
Chair, to assist you, don't switch off the video while we are fixing the picture so that we can assist, Chair, what Mema Jackie is saying.
I hope that is fine.
Well, that's fine, Chair. We will give you tips after the meeting of how you can locate it without even them seeing you.
No, thank you very much. When we were being trained, your picture was taken as one of the best ones. So I will take guidance from you, Honorable Judge. Members, can we start? Let's start with the two protocols. Can we flight the first one, Committee Secretary? A report of the Portfolio Committee on Justice and Correctional Services on the International Convention for the Protection of All Persons from Enforced Disappearance, tabled in terms of Section 231, subsection 2 of the Constitution of 1996, and the explanatory memorandum with the international. I think there is something that needs to be corrected there. of all persons from enforced disappearance dated to September 2022. Let's start by correcting that one. I think that's been corrected. Are there any corrections on page 1?
Yes, Chair, there's the same problem in the first paragraph. 1996 exemplary memorandum to the international to the convention.
Yes.
The same problem.
Yes, let's deal with that. Okay. Any further corrections?
Good morning, everyone. The first paragraph, the third line, abbreviation AICPP, that, and then the bracket is not closed. Yeah, just close the bracket. Thanks.
Okay. Just before we proceed, just one issue that I forgot to mention. If we are not done by 10:30, Honorable Horn has asked to leave at that time, but hopefully we will be close to finishing at that time, but we will be done with the 2 conventions or 2 protocols that need to be passed. Thank you very much. Can we proceed? Anything on page 1? Page 2. Nothing. Is there a mover for the adoption of the protocol as corrected?
I move, Chair.
Honorable Ngola moves. Any seconders?
Honorable Neo Drucken seconds, Chair.
Honorable Newvoort Drucken seconds. Any objections?
Chair, no objection, but as always, the DA reserves its position until this has served before caucus. Thanks.
Okay, thank you very much. The DA reserves its position. The protocol has been agreed to. Let's move to the next one. Draft report to the Portfolio Committee on Justice and Correctional Services on the International Convention on the Suppression and Punishment of the Crime of Apartheid, adopted by the General Assembly of the United Nations on 30 November 1973, tabled in terms of Section 231, subsection 2 of the Constitution of 1996, and the explanatory memorandum to the International Convention on the Suppression and Punishment of the Crime of Apartheid, adopted by the General Assembly of the United Nations on 30 November 1973, dated 2nd September 2022. Any corrections on page 1? Page one. Let's go down. Page 2.
Chair, page 2, Honorable Neo Drucken.
Honorable Neo Drucken. Page 2.
Page 2.7.
1.7.
Third line says wells. The S should just be removed, as well as, not
Yes.
as wells as.
Yes. Thank you very much, Honorable Neo Drucken. Any further corrections?
Chair,
Honorable Maseko Jele.
on paragraph 7,
Yes.
the last sentence, the Chair, I would request that maybe we change the last should not be overlooked, that one, that in the addition, the need for preventative measures as well as steps to redress the terrible harm caused by this crime should not be overlooked. I thought that maybe if we can say should be considered. I've written something that they should be considered, not overlooked, because I'm not sure if maybe I would be right.
Just read it again and adding your corrections. We just read it again.
The committee is of a view that there is a need to assert unambiguously that the apartheid is indeed a crime against humanity, and that practices associated with apartheid, racial discrimination, and other related intolerance will be punished. In addition, the need for preventative measures as well as steps to redress the terrible harm caused by this crime, it says here, should not be overlooked. I thought that maybe if we can change this, should not overlooked, it should be taken into consideration or considered, should be something like that. I've written somewhere here how I want it to be, but I would like that to change, Chair. I'm not sure if maybe the committee will agree with me with that one. Change, they should not be overlooked. See that one?
Yes.
That I propose that it should be where in addition, the need should read like this. Yeah, should be considered. In fact,
yes.
Yeah.
Yes. Members, what is your view?
Agreed, Chair, with the amendment should be considered. Steve Swart, Chair. Morning.
Thank you very much, Honorable Swart. So let's remove not overlooked. Thank you very much. Any further corrections?
Sorry, Chair.
Is Honorable Nibot Trochen?
Sorry, I'm just checking with what should it be replaced? Oh, sorry, please. Got it. Thanks, Chair.
Thank you very much. Ms. Silverstone?
Yes, Chair, I just thought that it should be harms rather than harm.
Which number?
Number 7. So we talk about the terrible harm. I just think the terrible harms might be better because there's more than one harm caused.
Okay, yes. Can we correct that at number 7? Yes. Thank you. Is there a mover for the adoption of the report as corrected?
Chair, I move for adoption as corrected. Thank you, Chair.
Honorable Masego Jele moves. Any seconder?
Honorable Ramulobeng seconds, Chair.
Honorable Ramulobeng seconds. Any objections?
Chair, no objection, just a reservation from the DA.
The DA has reservations. Any further objections or reservations? None. Agreed to. The treaty, the protocol has been agreed to. Thank you very much. Thank you very much to the department for the work done. Can we now move to the next item? That is the briefing by the department led by the Deputy Minister on the drug trafficking bill.
Chair, yeah, the department is here. I think it's Mr. Sevilla Mecha and Mr. Robertson. So they will be doing the presentation. I'll come in at the end if need be. Thanks, Chair.
Thank you very much. Ms. Silkstone, can you lower your hand? Thank you very much. Over to you, sir.
Morning, Chair. Mr. Robertson will take us through the presentation. Thank you.
Thank you very much. Mr. Robertson.
Thank you, Mr. Davidson, and
We thought that we were giving you a long leave with the cannabis bill. You are now back again.
I know, but it's all right. I'll proceed, Mr. Chairperson.
Chair, we have bewitched him to stay with us forever.
Yes, I can see.
Chair, I'd rather say prayed him to stay with us because this is another cannabis bill.
Okay,
Yes.
sorry for that.
I think the latter is agreed to. Proceed, Mr. Robertson.
Thank you, Mr. Chairperson. I prepared the slideshow, which is a short summary of the bill. Going to take the committee through the slideshow presentation. As a start, I must point out that there's 3 international conventions that regulate narcotics and psychotropic substances internationally. That is the Single Convention on Narcotics Drugs 1961, as amended by the protocol. It's the Convention on Psychotropic Substances of 1971 and the 1988 Convention against illicit trafficking in narcotic drugs and psychotropic substances. South Africa has acceded to these conventions. The 1961 conventions place certain substances under international control. The substances is listed in the 4 schedules to the 1961 convention. The 1971 convention included new substances, which was not traditionally included under the 1961 convention in its schedules, and placed that under international control. And then the 1988 convention complements the 1961 and the 1971 conventions with certain measures that deals with law enforcement, but also in the tables to the 1998 convention. There's certain substances included that can be regarded as substances that's frequently used in the manufacturing of narcotics or psychotropic substances. Our obligations in terms of the drug conventions is to the effect that South Africa must limit the production, cultivation, supply, import, export, etc. of the drugs and narcotics to medical and scientific uses. There's obligation on signatories to the conventions to prevent drug precursors from being used in the manufacturing of drugs. And there's a further obligation on the state party to criminalize under its national laws that gives effect to the drug conventions any criminal offense that aims to implement the drug conventions. In terms of Section 231 of the Constitution, the conventions is part of South African law, and the legislation that gives effect thereto are, amongst others, the Drug and Drug Trafficking Act, the Medicines and Related Substances Act, Prevention and Treatment of Substance Abuse Act, and also some other legislation of a minor nature. Insofar as it relates to the Drug and Drug Trafficking Act, the Act criminalizes the manufacturing and supplying of scheduled substances included in Schedule 1 of the Act, and it further criminalizes the use and possession and dealing in scheduled substances that is contained in Schedule 2 to the Act. In terms of Section 63 of the Drugs Act, the Cabinet member responsible for the administration of justice may by notice in the Gazette amend Schedule 1 and 2 to the Drugs Act. The Minister has effected various amendments in terms of Section 63 to the Drugs Act, and that was done in terms of government notices that was published as far back as 1996. The most recent one being the one that was published in 2014. In the matter, Jason Smith versus the Minister of Justice and Constitutional Development, the declaration or amendment of the schedules to the Drugs and Drug Trafficking Act in terms of Section 63 was challenged. The Constitutional Court confirmed the judgment of the Court of Quo that Section 63 of the Drugs Act is unconstitutional and invalid, since it purports to delegate plenary legislative powers to the Minister to amend the schedules to the Drugs Act, and it also declared the amendments that were affected in terms of Section 63 to the schedules of the Drugs Act invalid. According to the judgment, plenary power is the power that's usually afforded to Parliament to amend or pass or repeal an act. In terms of the Constitution, the legislature may not assign plenary legislative powers to another body, including the powers to amend an act of Parliament. Further held that the powers that is afforded to the Minister in terms of Section 63 of the Drugs Act is the conferral of plenary legislative powers to the Minister. And the Minister, by way of the government notices, actually amended an act of Parliament. And the court also held that the schedules to the Drugs and Drug Trafficking Act is actually part of the Drugs Act. The court further point out that the powers that's afforded to the Minister of Justice undermines the doctrine of separation of powers, and the court also point out that the Minister cannot amend the schedules to the Drugs Act by notice in the Gazette. The Constitutional Court suspended the order of invalidity for a period of 24 months to give Parliament the opportunity to hear the defects, and the 24 months period will lapse on 17 December 2022. The bill seeks to amend the Drugs Act to address the constitutional invalidity of Section 63, and also the amendments that the Minister effected in terms of Section 63 to Schedule 1 and Schedule 2 to the Drugs Act. To address the constitutional issue that was already pointed out in respect of Section 63, Clause 1, repeal Section 63, and the aim is to ensure that any amendment to Schedules 1 and 2 must be effected in terms of an Act of Parliament, as is contemplated in the Constitution. Clause 2 substitute Schedule 1 and Schedule 2 to the Act to effect the amendments that the Minister effected in terms of Section 63 to the Drugs Act to the schedules. Amendments to the schedules, I'll explain that in more detail. Schedule 1 to the Drugs Act deals with drug precursors and substances that is frequently used in the manufacturing of drugs. In terms of the bill, Part 1 of Schedule 2 is amended to include the following substances: this N-acetylmalonic acid, isofrole, 3,4-methylene dioxyphenyl 2-propanone, norepinephrine, including its optical isomers, piperonel, and safrole. These amendments were effected by the Minister in terms of Section 3 by notice in the Gazette. The next amendment relates to Part 2 of Schedule 1, and it inserts the substances hydrochloric acid, methyl ethyl ketone, orthotoluidine, potassium permanganate, and sulfuric acid, and toluene in Item 1 of Part 2 of Schedule 1. And it also amended Item 2 to Part 2 of Schedule 1 to exclude the salts of hydrochloric acid and sulfuric acid. Schedule 2 of the Drugs Act deals with drugs that is regulated in terms of the Drug and Drug Trafficking Act. And again, in Part 2 of Schedule 1, Part 1 of Schedule 2, sorry, substances are inserted that the Minister previously included by way of government notice in Part 1 to Schedule 2. And the substances are the tolbitol, caffeine, and it also did lead a substance that was in the Drug and Drug Trafficking Act as enacted, namely the substance of thalidomide. It further amend Item 2 to Part 1 of Schedule 2 to include thereto a paragraph that specify that all homologs of the listed substances are included in the schedules of the Act, unless they are listed separately in any other part of the schedules. Part 2 of Schedule 2 is amended, and the substances bitorphanol, dihydroetropine, atropine, and analogs, remifenatide and ziprol, is included in Item 1, Part 2 of Schedule 2. And again, Item 2 is amended by the insertion thereto of a new paragraph that also specify that all homologs of the listed substances in this part of the schedule is included hereunder, unless they are listed elsewhere in any part of Part 2 of the schedule. Part 3 of Schedule 2 is amended, and various substances are included therein. Again, this was substances that the Minister included in terms of Section 63 by way of a government notice in the schedule. And some of the substances that is included here, amongst others, synthetic cannabinoids, MDMA, ethylamine, ethylamphetamine, atropine, GBH, and methcathinone. It further amends Part 2 of the schedule, or rather Item 2 of the schedule, by again including a paragraph to the current Item 2 to provide that all homologs of the listed substances are included in the schedule unless they are listed separately in any other part of Schedule 2. I will clarify the inclusion of the substances later if there's a need to that. I think this is more or less what the bill aims to achieve. Thank you.
Thank you very much, Mr. Robertson. Does this bill have any effect on the cannabis bill, this drug and trafficking bill? And if yes, what is it?
Mr. Chairperson, in the schedules rather than amended schedules, the substances cannabis, dronabinol, and THC is included in the schedules to the Drugs Act. We have not deleted it. The original bill that was drafted actually did repeal cannabis and the related cannabis substances. But my submission is that we cannot do that in the interim. The cannabis bill will achieve that objectives. And we cannot currently, in terms of the bill, repeal that. If we do that, there will be, that substances will basically be unregulated until the cannabis bill is passed. So it's my submission, we cannot delete it in the bill or in the schedules to the Drug and Drug Trafficking Act. It will not really influence the cannabis bill, since the cannabis bill actually do repeal the substances that is included in Schedule 2 to the Drugs Act as substituted in terms of this bill. Thank you.
Thank you very much, Honorable Swart.
Thank you, Chair. Thank you, Mr. Robertson. So I'm just trying to understand correctly. Section 63 was declared unconstitutional because it purports to delegate the legislative power to amend the schedules to the minister, and the minister did that in government notices. And what you're doing now is you are taking it back to the Act and putting it into the schedules in the Act. In so doing, that is how you seek to remedy the unconstitutional aspect to that. I think that's, if you can help me understand that. Firstly. Secondly, I was going to raise the issue of Schedule 5 to the cannabis bill, which the chairperson has now raised. You have to a degree explained that. And my understanding then would be that amendment, should the cannabis bill go through, that schedule is then amended in legislation and not by government notice. So that would be acceptable to remove the definition of cannabis in terms of the draft cannabis bill. And then, of course, I'm sure the Deputy Minister would like to comment on the delay. This issue, these issues come up continually. One of my concerns is that counsel for the Minister, in paragraph 94 of the judgment, one presumes, conceded that a period of 24 months will be adequate for this process of amendment. And now we're sitting at the end of this period of beginning of September to December to cover what seems quite a straightforward bill. Again, we would need an explanation for the delays, because this now places inordinate pressure on us and, of course, the NCRP and then the President to sign in the law by the 17th of December. My question is, if it is not done by then, there's no reading clause, what is the impact if the legislation, and now given the fact that the order is against Parliament, but if the legislation is not amended by the 17th of December, I understand the order is prospective, not retrospective, but clearly there'll be a very significant impact should the legislative process not be completed. Thank you.
Thank you very much, Honorable Swart. Honorable Ngola.
Thank you very much, Chair. I think you have covered me as it relates to the cannabis bill issue. Mr. Horn is putting a finger of emphasis on what we have said last time when we're discussing this bill with deadline, constitutional court deadlines. I think what he's saying is actually accurate and in line with our view in that particular meeting. The last issue, Chair, that I would like to ask as a question is in relation to paragraph 2.6, 2.7, 2.8 of this presentation, as it relates to the substances and all that. You know, those substances, Chair, are more scientifically deep, such that not anyone can understand what needs to be there and what needs not to be there in the prohibited drug use. So I want to check with the department if they did solicit an expert scientific opinion as it relates to those substances that which are supposed to be inserted in the amendment bill. Thank you, Chair.
Thank you very much, Honorable Ngola. Any further questions or input? Over to you, Honorable Deputy Minister, to your team.
Thanks, Chair. Yeah, look, as Mr. Swart has said, this bill is about, well, the issue and the reason for the bill is that Section 63, where the minister could simply add to the bill, was found to be unconstitutional. The Parliament can't delegate its powers. It's a 92 bill, so it was pre-constitutional. And what this bill then effectively does is just take out Section 63 and then go and put in all the drugs that the different ministers going back to, I think he'd said the first one was 97, had put on. So it's simply status quo. It's nothing new. Obviously, because you're now adding all these drugs, I suppose you need to know what you're adding. I assume, and Mr. Robertson can give more detail, that when the minister did attempt to add drugs to the schedule, that this was on the basis of recommendations from the Department of Health, but he can maybe indicate what process was followed then. But because you are now amending it, theoretically, you should know what these drugs are. As far as the question of the lateness, the department, the officials, Mr. Sivelemecha and Mr. Robertson must respond on that. As I'd said to the committee on Tuesday, this bill, I think, was due into Parliament in February or March, which even then is quite a long time because it's effectively the same act that we've got now, just with Section 63 removed. But that was just by clarity. It should then be an easier process. Thanks, Jeff. I can then give to Mr. Sivelemecha or to Mr. Robertson or both.
No, just before you leave, DM, we said that you should, the ministry or the department should consider asking for an extension. Is there any progress on that?
No, I mean, is it really going to be difficult to pass this bill in 3 months, given it's non-controversial? I mean, otherwise, I guess we could approach the court for an extension. but is it not possible?
I think yes, Mr. Swart, Honorable Swart.
I actually object to the Deputy Minister's nonchalant approach, given the fact that this order was given in the High Court in 2015 and in December 2020, to just say 3 months. We've got no idea what all these drugs are. I would also like to know, the last government gazette was on the 28th of March 2014. The health department might want to add new drugs to this. So I do think that we should object. And Deputy Minister, I know you well, and I know you don't intend it badly, but it just, you yourself have said this should have come to us in February. Now we're sitting with a number of bills that have got pressing constitutional court deadlines. And I don't appreciate the fact that just say, it's fine, we must just pass it. It's got to go through various processes. And you as a member of this committee should know that it takes time to go through our process, to go through the NCOP, and then allow the president to sign it by the 17th of December. My question about the impact if it is not signed by them, that is key. And yes, it's maybe not a controversial bill, but you correctly said we as legislators need to understand what are the drugs here, what drugs are we dealing with. So there are various implications that we also need to understand. Thank you.
Thank you very much. I think the points that Honorable Horn is raising, I think he correctly articulates our fears as the committee. You have also constituency breaks in between. The NCOP is not waiting, is not sitting and waiting. It has got also a lot of its own responsibilities and other bills before it. So I generally do not think that 3 months can be taken, that if any bill that no, you have 3 months, both houses, including the president, should accent to the bill within 3 months. I don't think that is fair at all. I don't think it's fair.
Chair, can I come back up?
Yes.
Yeah. No, if the committee wants us to apply for an extension, because my understanding is that on the 17th, that those schedules no longer are legal if the bill is not passed. If the Portfolio Committee wants us to approach the Constitutional Court for an extension, then we will have to do that. I was just hoping from an expense point of view that could be avoided. Mr. Swart, I'm not being nonchalant. It's, I think, the difficulty of executive authority versus accounting officer and the department, and that we cannot, or it's more difficult to, the officials don't answer directly to us, but I'm extremely annoyed about this bill and that it is late to Parliament. And it's against the undertakings that I was given by the officials. And as I said, I myself had to intervene to get this put on the Cabinet Committee agenda because it just wasn't going. So I'm sorry, Mr. Swart, if I came across as nonchalant. Maybe it's just covering up annoyance on the issue. But if the committee feels that the department should apply, then we will have to do that. And then as far as the issue of Mr. Swart's issue of, look, this is keeping the bill as it was, the act as it is. I think if Department of Health wanted other drugs, they would have had the opportunity to do so. So we should just proceed with what is here, particularly given the time. They haven't indicated they want anything else, as far as I'm aware. The other aspect in terms of the gap between, just because Mr. Swart raised it, between the High Court decision and the Constitutional Court confirmation. Mr. Swart, you will know that once before we tried to bring a bill before the declaration of invalidity was confirmed by the Constitutional Court. So we were more than on time. Unfortunately, the Constitutional Court in that case, I seem to think it was the one around, was it the one around children, underage children having sex? It was either that one or the Media 24 case. The Constitutional Court, unfortunately, didn't just confirm the High Court, they added more issues. So we actually had to withdraw the bill and reintroduce it with those sections. So because of that, we wait for the confirmation order to come. But in this case, I do not understand why, as this bill is simply the existing act, why it could not have been done very urgently. Thanks, Chair.
I think, Honorable Deputy Minister, the issue that I think we will take issue with as far as the executive authority is concerned is that it's not for the first time we are raising this matter. We have raised this issue of late coming of constitutional court bills since the beginning of the term, and we are moving towards the end of the term. If the accounting officer does not implement what you want him or her to implement, or to do or to make the officials responsible to be accountable, what have you done to ensure that Parliament's fears are addressed? Because from the time we started, we have been on the back foot, firstly from the bills of the last Parliament, and we made an undertaking as Parliament, as this portfolio committee, that we shall ensure that bills that are arising out of the 6th Parliament, all of them will meet the Constitutional Court deadlines, and we have not been able to, and because of the late coming of the bills. The issue that when you come back, even for the PRRR, we will have to ask you, what actions have you taken? If you know that the officials are not doing what they're supposed to be doing, and you have an accounting officer, I think an action should have been taken, because this is straining the relationship between the two arms of government, that is Parliament and the courts and the judiciary.
Chair, we discussed this on Tuesday. When I've raised why is this taking so long, I was given a response of problems with the capacity of the legislative development section. That issue I've then taken up with the Director General about what is being done to fix that capacity. As Ms. Pillay, who's the head of that section, legislative development, had raised on Tuesday, there have been issues of COVID, Ms. Teresa dying of COVID or passing away due to COVID, Mr. Robertson, who's here, having COVID very badly. And then it's also been issues of experienced staff members retiring. So I thought we'd covered that on Tuesday, and I thought you wanted a sort of further report on that. But from my side, when I've raised it, I mean, I have had various meetings with legislative development to check on the program. Dates have not been met. Then when I've raised it, the issue has been lack of capacity, and that I've taken up with the Director General.
Okay. There was a question which I thought might, I think it was an important question from Honorable Ngola, that we need to understand what we are passing. I think one of the fears that Honorable Ngola is trying to articulate, that we might have through the public comments, other organizations wanting to add certain drugs. Maybe there might be a plethora of them. And the issue would be on what basis would we say we don't add them or we add them?
As you know, the bill cannot be added to unless it is by the approval of the House. So I would say rather than preempt things, that it's put out for public comment. I'm not sure if it's been put out already, seeing the bill was introduced on Tuesday, and we had asked that it be submitted or put out for public comment as soon as possible. But I would say we wait and see whether there are any submissions. We can't preempt what the public are going to say. And if there are submissions for further drugs, then the department would need to respond to that.
Hence,
but we have had, I mean, in terms of the amendments to, as far as I know, the way this process has worked is the Department of Health approaches the Minister of Justice to get the schedule amended. And we haven't had further amendments requested from the Department of Health.
Okay, thank you very much, Honorable Nibot Trochen.
Thank you, Chairperson. I have two concerns, but the Deputy Minister has just covered one of the concerns about why the bill was not moving. And then in terms of if the Department of Justice, in consultation with the Department of Health, those were my two concerns, but the Deputy Minister has just covered that. However, the Deputy Minister has said that if we don't pass the bill, the schedules will not be legal. So I am very concerned about that because we have a severe problem with drugs in South Africa. So you know, it is a big concern if we do not pass this bill in time, and what do we do if this bill is not passed in time? Thank you, Chair.
Thank you very much, Honorable New Vote.
Can the Secretariat, sorry, Chair, can the Secretariat allow pinning, please?
I think the Deputy Minister has already answered, and I think part of what you are asking, I think it will be covered through the department asking for an extension, so that we are able to cover any eventuality if there can be an unexplained delay in the process, so that we are also covered. We might not be anticipating it now, but we don't know what will happen. We don't know what the public comments will give us. But we will do whatever we can to ensure that we process the bill as soon as we can. Honorable Tiam.
Yeah, Chair, just on that point, sorry, it's not correct that the entire schedules will go. It will be the additions that the Minister of Justice made to those schedules since the Act was passed in, what was it, 92. So it would only be those ones, but that is bad enough. We can't afford to have a situation where those drugs that have been added are not down on the restricted list. So basically, if the committee is saying it's concerned that it won't be able to pass the bill before the deadline, which I think the last sitting of Parliament's like towards the end of November, both houses, then we would have to approach the Constitutional Court. I would, though, still request that the committee proceed with haste on the issue, and I hope that the bill will be published for comment over the weekend, because there's no basis for that not to be happening. We had indicated from last week that the bill had been approved by Cabinet and was about to be introduced. Thanks, Chair.
Thank you very much, Honorable Swart.
Chair, I appreciate the Deputy Minister's explanation and the fact that he intervened to ensure that the bill was before us. I'm also a bit concerned that even an application for an extension might not necessarily be successful. So given the fact that he has given us an explanation, and the department probably is also going to try and explain it, but we are going to have to expedite this as much as possible from our side. You can't run the risk that you can imagine possession of these very serious drugs from the 17th of December. All those drugs that have been noted on the schedules from 1996 will then no longer be unlawful to be possessed, or, as I understand it, or traded with. And I think the implications are vast. And I think we need to do everything in our power, as Honorable Niba Drukhan pointed out, to pass this as quickly as possible, and then to get it through to the NCLP. I can't say more than that, just to emphasize the point, to push it as quickly as possible. Thank you, Chair.
Thank you very much. The bill will appear on the newspapers this weekend. There's also a procurement process to be followed in Parliament. So we had to follow that particular process of procuring the national newspapers. That is why there was a delay. We will advertise. I'm told that the maximum will be 3 weeks. So which means from this weekend it will be on the newspapers, and we will give the public 3 weeks to comment. Then thereafter we will start with the normal processes of public hearings, if there is, or if there are comments. If there are no comments, then we will move to the second phase as the committee. But I think it would be important also that the NCOP be alerted to this conundrum, so that they are, once we pass it as a National Assembly, then they will be on the other side, be ready to process the bill as soon as possible. And the President is also alerted to the challenge. We must try to meet the deadline. But I do think that on a weekly basis, even if it's just a phone call, Deputy Minister, we would like to be updated as to how the court process is proceeding. Thank you very much. Honorable Swartz, your hand was up.
No, Chair, I'm covered, because I was going to just question the rationale for 3 weeks, but I presume that advert's already out, so that's fine. Thank you, Chair. Thank you.
So less than 3 weeks, won't we have challenges if we are giving people too short a notice?
I don't think so, because it's not a controversial bill, but I would presume those adverts have already been placed for the weekend. So I think it's academic. I think we should then just leave it. But given the urgency, maybe 2 weeks would have sufficed. But I think the advert's probably been placed already. Thank you.
Thank you, Ms. Stone.
I just wanted to add that we have done a bill we have advertised for less than 3 weeks in the past, given the urgency of the matter. And maybe Bonani can advise as to the advert.
You're saying we have done the bill in 2 weeks? We said in 2 weeks or 3 weeks?
No, we have advertised for less than 3 weeks in the past. In fact, I think the one time we advertised for 1 week, given the urgency of the matter. So in certain situations where it's very urgent, we can reduce the time. Or we have done it in the past, should we say?
Okay.
Not in this parliament, but in previous parliaments.
Okay. And there were no challenges?
No challenges at all.
Okay. Mr. Ramano?
Good morning, Chair. I fully agree with Christine. We were going to propose that we advertise for 2 weeks. And like you indicated, we've done it in the past.
Okay. Members, are we happy with 2 weeks?
Agreed, Chair.
Agreed. Any person against the 2 weeks? None? Agreed too. Are there any outstanding questions or replies to the questions?
Mr. Chairperson, sorry, I probably need to respond to some of the instances. I must point out that in terms of clause 3 of the bill, there's no implementation clause. So if the bill is adopted by Parliament, it will immediately come into effect. So the President don't need to put it in operation by proclamation in the Gazette.
Okay.
Secondly, the Deputy Minister did indicate that there is problems if you don't meet the deadline. One must also take into account that the substances that the bill aims to insert in the schedules is also part of the Medicines Act, mostly Schedule 7. So for the prosecution of such offences, one can probably argue that yes, it can be done in terms of the Medicines Act. The Medicines Act contain prohibitions against the distribution of certain chemicals, and all the chemicals that's in Schedule 2 will be covered by criminalization in terms of the Medicines Act. But again, the Medicines Act, the schedules thereto, is also amended by way of amendments to the schedules by the minister. So one can probably foresee that a similar constitutional challenge may be raised against the Medicines Act in this regard. The Deputy Minister did explain, okay, but sorry, let's come back to the problems. The problems will relate mainly to the effect that since the judgment date, the schedules has been declared invalid. So prosecutions that has been instituted, etc., from the date of the judgment probably need to be stopped. And that has got certain problems for law enforcement. The Deputy Minister did explain to Mr. Swart that the repeal of Section 63 of the Act will have the effect that any amendment to the schedules of the Act must now be done in terms of primary legislation. So every time the schedules needs to be amended, amendment bill must be introduced and must be taken through Parliament and adopted in accordance with the Constitution. I'll explain the criteria later on regarding what was considered to include the substances in the schedule. I know the department is quite late with this bill. I think it was submitted to the state law advisors around about April, May, beginning of this year for preliminary certification. I must remember that the steps that must be followed to get the bill introduced in Parliament, among others, require a SAIAS to be compiled. This takes some time. We did get the exemption in the end for the bill in order to expedite it. Then the next structure that considers the bill is DEFCON. That was done quite soon. And there was a delay to place the bill before the JCPS DGs due to the fact that the meeting in which it was supposed to be considered was actually cancelled, so that delayed the implementation of the bill by a whole month. Further on, regarding the delay from our side, One must take into account that the Drug and Drug Trafficking Act has been enacted in 1992. It's quite a long time ago. And there were various amendments to the Drug and Drug Trafficking Act. The department has compiled a new bill to regulate drugs and drug trafficking in South Africa. That was finalized in draft, but we had substantial problems with the schedules to that bill. Due to the fact that expertise that could verify the correct scheduling of the substances is actually lacking. We did get assistance from the South African Police Service, but in the end it took too long. We couldn't get everything in order to promote a comprehensive bill. And then we decided for the quick fix in terms of the current bill before Parliament. I must point out that in terms of the Drug and Drug Trafficking Act, there's various presumptions that is still in the statute book, and that's contained in sections, I think, from 20 to 22, rounded about. Presumptions relating to dealing in a drug. If a person is within 100 meters from the school, and also a person is deemed to deal in drugs, if he's in possession of some of the scheduled substances. There's also a deemed knowledge provision regarding the owner of a place where drugs is found. The other bill addresses that, but it couldn't be addressed here. There was also a judgment that declared certain of the powers of the police officials in terms of Section 11 of the Drug and Drug Trafficking Act unconstitutional. The other bill aimed to address that, but be that as it may, we just couldn't finalize a comprehensive bill in time to deal with this. Regarding the insertion of new drugs in the schedules, there is various amendments that need to be effected to the current schedules of the Drug and Drug Trafficking Act, which is not currently included in the bill. I believe that somebody has been tasked with the drafting of a bill that will amend the current schedules to include all the other substances that is in the conventions and that has not been taken up in the schedules to the Drugs Act as proposed in terms of this bill. So yes, there is amendments that needs to be effected, but my submission is that can be done at a later stage. Okay, let me explain the substances that has been inserted in the schedules. Regarding part 1 of Schedule 1, that deals with scheduled substances or drug precursors or chemicals that can be used, or chemicals that's frequently used in the manufacturing of drugs. If one look at the 1988 convention, Article 12.4 of that convention provide criteria that must be taken into account to insert a substance in one's national law, or also for purposes of inserting it in the tables to the 1998 convention. And the criteria are, amongst others, the extent, importance, and diversity of the illicit use of drug precursors, the possibility and ease of using alternative substances for illicit manufacturing of drugs, must be considered whether the substance is frequently used in the manufacturing of drugs, and whether the volume and extent of illicit manufacturing of narcotic drugs or psychotropic substances creates serious public health or social problems, so as to warrant international action. I did point out previously that South Africa acceded to the drug conventions, and the drug conventions therefore becomes part of our domestic law. And there has been judgment. I think Glenister case is one of that judgment, which do spell out the obligations of South Africa to give effect to its international obligations in terms of a convention. So in respect of Schedule 1, the current scheduling of the substances in terms of the 1988 convention were considered and were mainly used as a reference or basis for the inclusion of the substances in that schedule. Regarding acetylmalonic acid, that substance is currently included in Table 1 of the 1988 Convention. That substance is frequently used in illicit manufacturing of methadone in South Africa. It's manufactured through a process where one reacts anthranilic acid with O-toluene together with phosphor, and you can then produce methadone. Isosafrole is included in Table 1 of the 1988 Convention. And
sorry, Mr. Roberts, I'm not sure whether members would want to have that detailed explanation now, or we might want to deal with it when we are processing the bill, maybe when the department is replying to concrete public comments. I'm not sure whether members would want to have each and every detail now or later. Honorable Swart?
No, Chair, I agree with you. Maybe we can ask Mr. Roberts to prepare us a document just explaining the different drugs so that we've got something in writing, and that would probably be helpful to us, just because there is reference to the international conventions, etc. Just a brief document on the justification for the inclusion of the various medication. Thank you. The various drugs. Thank you, Chair.
Yeah, I think that would be much better. Members, is there any objection to that?
No, Chair.
None, agreed to. Mr. Roberts, can you do us a document, a brief document that will explain that, but the process as we have been explaining it? Can we move to the next question or reply?
Chairperson, I think I did cover most of it. And yeah, okay, I did explain what the Act aims to achieve. It is, I think I did cover all the questions. If I missed something, can you just remind me, please?
Honorable Swart?
Thank you, Chair. I just wanted Mr. Roberts to explain the implications. You said since the judgment date, schedules have been invalid and prosecutions need to be stopped. Can you just unpack that a little bit, because I need to understand what is meant by that? And has there been an engagement with the SAPS and the NPA in this regard? Because then my understanding is incorrect, that this only becomes relevant on the cutoff date, 17th of December, but from what is it? No, but my understanding was the declaration of invalidity was suspended until the 17th of December. Maybe you can just clarify that point to me.
Yes.
Thank you, Chair.
Thank you very much.
Thank you, Mr. Chairperson. When the court declared, okay, first, court declared section 63 invalid. Next thing is the court declared the amendments invalid from the date of the judgment. Then in terms of its powers, suspend the order of invalidity for a period of 24 months. So the current amendments to the schedule will be valid till 17 December 2022 in terms of the Constitutional Court judgment. I know there is the rule that if a law is valid at a certain period of time, and especially in criminal proceedings, and you aim to prosecute a person, and there's a criminalization provision, you can proceed with it and prosecute a person, even if the validity of that criminalizing provision will expire. But one must also take into account other concerns, amongst others. If the inserted substances is not amended by 17 December, that suspended order of invalidity is no more. So it will become problematic, in my view, to continue to prosecute a person for such offences if it's no longer in the statute book. It's just a concern that I have from my side. Regarding engagement with the police and the National Prosecuting Authority, there's no in-depth consultation or engagement with them on this issue. I think they're well aware of the implications if the bill is not passed timelessly. But at least they have till 17 December at least to enforce the current provisions in terms of the bill. It will become problematic thereafter if the substances is deemed not to be under schedules to the Drug Trafficking Act anymore. But if we see that there's going to be a substantial delay and we need to apply for extension, we will obviously also request them to assist or support or make inputs regarding any application for extension. It's my submission, and you will also see if one look at the document that I will prepare to the committee, all the substances except for one that's currently in the schedules to the Drug and Drug Trafficking Act is substances that has been included in the schedules to the drug conventions. Yes, thank you.
Chair, may I come in just before the DM does, just to ask, maybe you can help me understand this, Chair, if I may?
Please proceed.
DM and Mr. Robertson, do you understand it correctly that, and hopefully we will pass this bill, or hopefully an extension will be granted, but if not, the period of invalidity that has been suspended as per the court order then kicks back to 2 years ago, to 2020, when the order was given of invalidity. That obviously all the prosecutions then for the last 2 years would be in jeopardy, if I understand it correctly, from the date of the judgment and the court order, because that court order is suspended for 24 months. But if we don't pass it, then it kicks back to that date, if I understand it correctly. Thank you.
Thank you very much, Honorable Swart. Honorable Deputy Minister.
Chair, yeah, my understanding, and I think Mr. Robertson did did clarify it that the problem will only come in if the law is not passed and in effect by the 17th of December. The declaration of invalidity is there, so any prosecutions can continue under the Act. The problem would be if it's not passed. And just to re-emphasize the point to the officials, the committee has asked for an application for an extension. So we will have to start that process immediately, not wait to see how things go. Thanks, Chair.
Thank you very much, Deputy Minister. I think that would assist. But I do think that there is a need for a serious conversation between Parliament and the Executive. For instance, Mr. Roberts says that at some point DEFCON did not sit, the meeting was postponed, and notwithstanding that we were faced with this particular challenge. I think we should have that particular conversation, that both the executive and the legislature we have to agree amongst ourselves as to how do we really prioritize the issues affecting constitutional court deadlines, because we can see with this bill that the implications are huge, really huge. So now it can't be acceptable that within the value chain, there would be people who would not see the magnitude of this particular problem and treat these things as any other legislation, because the duty of all of us is to manage risks on behalf of the state. That is the duty of all of us. Whether you're an official or you're a politician, that is our duty, that we have to manage risks on behalf of the state. So if those risks materialize under our watch, then there's a serious problem, a serious one. So we will appreciate, Deputy Minister, if that can be followed up. An extension is applied for, but on our side, since we have agreed on 2 weeks, which means we will try and push the bill that by the end of this month, we should have passed it through the National Assembly, and then the NCOP would have to follow its own processes and prioritize it. But if I think we can pass it before we adjourn, I think it will give the NCOP a breathing space. And bearing in mind that Mr. Roberts has also said that it does not need an assent by the President. So which means once the NCOP has passed it, then it will come to effect. But we should not put ourselves and the country potentially under these conditions. It's unacceptable. Honorable DM.
Yeah, Chair, just to clarify, Mr. Sebele Mecha didn't say it doesn't need to be assented. What he was saying is usually there's a 2-stage process. That is, the President assents, and then at the second stage is the implementation. What he was saying is that this doesn't need an implementation provision by the President, implementation action. The President will still need to assent to it. Thanks, Chair, just to clarify that.
Okay, so that process also would need to be managed, because if both houses meet the deadline and the President does not assent to it, then that will be another challenge. So we would need to manage all of the stages as we try to meet the deadline. Thank you very much, members. I think the last issue that I think we'll need quickly to deal with, on Thursday next week, we will be debating the Traditional Courts Bill. It's the bill that passed through the National Assembly, through the National Council of Provinces, and there were minor changes from the NCOP and they are back with us, and as the committee we have approved those changes. So would we need to debate? Do we need a full debate, or parties will behave with declarations? Honorable Swart?
Happy with declarations, Chair. Thank you.
Happy with declarations. Any contrary view? Honorable Deputy Minister, are you having a different view?
Chair, I would like to have been able to respond, because I think there will be a number of issues raised that require a response, which I can't do under a declaration, because that would be MPs. But if it's fine, if that's what people want, one can maybe issue a statement out later if need be.
Okay. So what do we do now? Let's manage that outside of the meeting, Deputy Minister.
That's fine, Chair. Thank you.
Thank you very much. So we agree to the declarations. Thank you very much. The meeting is adjourned.
Thank you, Chair.
Thank you.
Recording stopped.